Let's tell you now about a case that's currently before the High Court which could change the entire legal concept of maternity leave. Applicants are arguing for gender-neutral language to be used in the Basic Conditions of Employment Act. For more on what this could mean, we're joined by Webber-Wentzel Nkosinathi Thema. Very good evening to you, Nkosinathi. Grateful for your time. So let's talk about why this is such an important legal battle and what the objective is here.
Good evening, Tembegile, and good evening to the viewers at home. You're quite right, Tembegile. If successful, the case will have a massive impact on the parental leave regime in South Africa. So right now, as you might know, maternity leave and broadly parental leave is governed by Section 25 of the Basic Conditions of Employment Act. And with regards to the maternity leave provisions, they actually do not afford an opportunity to the co-parents to nominate a primary caregiver and thereby place all the care duties on the mother, whereas the other parent is having to spend that time away from the child. And so this case is quite important in that we have asked the courts to declare Section 25 of the BCEA as unconstitutional, and to, in the interim, whilst Parliament is given an opportunity to remedy the constitutional defect, then the courts will read in some language which will make those maternity leave provisions more inclusive.
And who would benefit most from such a change, Nkosinathi?
So the intention, Tembegile, is for both parents in a partnership to benefit from those maternity leave provisions. So for instance, if you consider Section 25B, which deals with adoptive leave, and Section 25C, which deals with parental leave for surrogacy commissioning parents, you note that there is a choice there. So those parents are able to take either the 10 weeks that is provided for in those provisions, or they can take the 10 days of parental leave. But Section 25, which deals specifically with maternity leave, does not provide that choice. So as to who would benefit, really it should be the choice of both co-parents as to how they want to benefit from that provision. So for instance, if you consider Section 25 as it currently is, you find that the other co-parents, like I said, is taken away from the child at a young age. However, if the birthing parents is able and willing to and actually wants to go back to work, they should have that choice, and the other co-parents could then be the primary caregiver of the young child.
You use the phrase birthing parents. Am I right to say that the change that's being sought would speak exclusively to what would be commonly known as biological parents?
Yes, indeed.
And as things stand, how much of a basis is there to prove that basically the law as it stands, if all intents and purposes, is unfair or perhaps even unkind to people who are in the workplace but would like to do more as a parent or get more help from the other parent?
So your question, Tembegile, speaks to the changing nature of parenting relationships, right? We no longer have family structures which resemble, the olden days where women were expected to be the primary caregivers. We are now saying that the time has come to recognize that even fathers, in this instance, can be primary caregivers of children, and that should both co-parents be willing and should they want to, then they should have that option. Currently, they do not have that option, and that's the constitutional defect we are trying to correct.
I'm curious whether there are any South African workplaces, given that we are in a changing world of work, any workplaces domestically, perhaps even abroad, where we've seen such a change made on the basis of a company decision, and how, in fact, it's been good for the well-being of working parents, be it the mother, the father, or anyone else who cares for a child.
So the provisions in the BCEA, I would describe them as minimum provisions. It does not preclude employers from going over and above what is provided for. However, in terms of international jurisdictions, I cannot think of any right now on top of my head, but I do know that particularly in the European countries, there are far more generous leave provisions that both sets of parents are able to benefit from. And that's the system we are trying to move South Africa to.
And is there a sense that, given, once again, that this is a changing world of work, that our labor law has been agile enough to keep up, especially on issues such as parenting, and the fact that increasingly workers are saying, well, they want to exist beyond just being an employee and workplace satisfaction, but that it all basically has to work in harmony, in tandem, basically?
I think, Thembekile, the world has come alive to the fact that employee wellness is all-encompassing. It's not necessarily always about the perks that an employer may provide employees, but it's all-encompassing, including affording employees the time to actually live their lives outside of the workplace. We learned this during the COVID period. In South Africa, we have structures like NEDLAC that are supposed to be driving those policy changes. NEDLAC consists of employers, it consists of government, and they sit and they debate these policy decisions. As to how agile and as to how quickly they move, I cannot speak on that, but we do know in South Africa legislation takes time to move through Parliament, and when you have to consult additional structures like NEDLAC, it may take more time still.
With that in mind, then, just on the issue of NEDLAC and the consultation that would have to happen between government, labour, business, etc., how much support, how much resistance is there, if you've been able to gauge it all, to what you're proposing, what you're pushing for, in fact?
So in the application, this is an opportunity to speak briefly about the parties. There are a number of applicants in the court proceedings. The first and second applicants are our clients, Mr. and Mrs. Van Wyk. The third applicant is Sonke Gender Justice. They are seeking a 4+4 system. The Commission for Gender Equality, which is a Chapter 9 institution, is a fourth applicant, and they are seeking a more generous leave provision for all classes of parents. And on the other side, we have NIASA, which came in as an amicus, a friend of the court. NIASA represents employers. They represent employers, and they have been vehemently opposed to the relief that we seek. Likewise, government has also been opposed to the relief that we seek. However, as I noted, that the Van Wyk do not want a 4+4 system, meaning 8 months for both parents, but rather a choice provision. The Minister's Council during the proceedings noted himself that that kind of system would actually solve any detrimental effects that a 4+4 system would have on structures such as the UIF. So I would say that, those employers that fall within NIASA as a representative body do oppose the relief sought. The minister, from what we heard during the hearing, is not so opposed to that the choice system that we've asked the court for.
Good to speak to you, Nkosinathi Thema. Thankful for your time tonight. Thank you.